and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Boy, and I wonder if there's any legal queries this morning arising from the floods and insurance. There may well be. And if there are, we've got the bloke to answer the questions. David Whiting, well-known Melbourne solicitor. Good morning.
Good morning.
You survived the floods, where you
I
are.
did survive the floods. I can remember years ago, there's the road around the river at Maribyrnong, Chifley Drive,
Yes.
has light telegraph poles, and you can see where the water level was. The 1974 level was very high.
Very high indeed. And this one was too. No, he managed to keep his feet dry, but we know that you didn't. So if you've got some questions, give us a call. 1300 222 774. You had some homework?
I did. I had Frank from South Melbourne had a question in relation to plane trees. So he's in the city of Port Phillip, and the question that he had, these are roadside trees that are pulling up the bricks on his driveway or pushing up the bricks on his driveway. And my concern was there's a piece of legislation called the Road Management Act, which is designed to protect councils and other road-making authorities. And while there are some restrictions on civil liability, there's no restriction on councils being responsible for damage they cause to other people's property. So, Frank, you're okay.
Hey.
Have a go at the council.
That's good to know. Anyone else?
Nope, that was it.
That was it. Then on to you. 1300 222 774 is the number. Let's see. Judy is calling in. Judy, where are you calling from?
Mulwala.
Go ahead. What's your question?
My brother lives in a Victorian country town, and he's recently moved into an aged care facility run by the local district health service.
Yes.
They have a contract with one of the two chemists in the town to supply all their pharmaceutical needs, and insist that all the residents and patients use that chemist. Now, my brother wants to continue using the second chemist in this little country town because he has a long history with them.
Yes.
And they understand he's got fairly complex medical needs, and they understand that he needs exactly what's prescribed and so on. So my question is, can the health service legally oblige him and the other residents to use their chemist? And if not, what can he do to get back to being able to use his own chemist, please?
My view is that he would be entitled to choose his own pharmacist, but that would then make him responsible for ordering the prescriptions and everything else.
Yep.
Now, at the moment, the facility probably has a contract with a doctor or a couple of doctors, and then they assume responsibility for filling the scripts and then collating and distributing the drugs. If he wanted to change that system, you're adding an extraordinary level of complexity to their management.
Now, one of the doctors who comes is from his practice.
Yes.
And my brother actually goes to the doctors at their own at his their practice, as distinct from waiting on them coming to him. He's still quite able.
Can I say my recollection of the aged care facility agreements that I've seen, and most of them are identical, I don't believe there's a requirement that you use a particular pharmacy. The question will be, how does he logistically ensure that his drugs are dealt with separately? That's a discussion you have with management.
Yeah, they're not prepared to have it.
It may well be he then now has to assume responsibility for his own medication.
He'd prefer to, but they won't let him.
Does he have competency issues?
Yes. No, he can handle his own meds. He was until he moved in very recently.
I think I'd be looking at the assessment that got him into aged care and see if there was a mental impairment that would stop him. And then you have issues of, well, he's now got to keep his own meds in his own room. Is he going to self-administer as well, or does he want them to do that? Because in an aged care facility, there's generally a nurse with a trolley where everybody's medication is contained and locked, and that's their security level. I just don't know how your brother now assumes responsibility for minding them.
But you think that that he can have, or Judy can have, a conversation with the managers about using the preferred chemist?
Well, yes, but I suppose it's really just a question of his choice rather than... The prescriptions will be identical. The drugs he gets will be identical.
Yeah. So. Judy, we hope that's helpful. We'll leave it there. Thank you so much. Peter in Fairfield. Hi, Peter. What's your question?
Oh, hi, David. I bid on a vehicle on an auction site, and I won the vehicle. the next day they sent me an invoice regarding the vehicle, and I noticed the compliance plate and the built plate, the numbers didn't match up. I just queried it. I spoke to a guy and he sent me an email saying they were going to investigate it. In the meantime, they cancelled my bid, I suppose, and they now want to fine me 10% of the auction amount. And now I'm getting letters from the collection debt.
No, sorry. So you bid for a vehicle, and you have now they're now saying you cancelled the bid, are you?
Well, because I didn't. Well, look, it's in the contract, of course. I didn't pay within 2 days.
It will all depend upon what your rules were in terms of the auction. So you need to look at the auction site, download the terms and conditions that applied to your bidding.
And if it said that payment had to be made within 2 days, they're within their legal right, are they?
Well, the question will be, what vehicle did he buy? Now, a vehicle has a compliance plate. And what was the other number, Peter?
The built plate. When it comes out of the factory, it has a stamped plate.
But the compliance date and the build dates are for imported vehicles are never the same. They could be apart by a year or more.
This was probably 5 years difference.
Okay, then I'd be going to the manufacturer and sort it out. But you're going to. But this is a different question. You need to look and see at the terms and conditions of your bid.
Yeah, look, I think that they make it pretty tight. That even though I was just querying it, if they had have come back to me on the same day and said, "Look, no, that's it," I would. Okay, then they said either buy it or we're going to pay 10%. But they strung me on for 2 weeks.
Peter, look at the terms and conditions. I can't give you advice as to what they say.
Sorry about that, Peter, and I hope that's useful, at least going to that. The terms and conditions are going to be a yard long, aren't they?
No, probably 2 or 3 pages. A mere nothing.
Yeah, all right.
600 mil.
Just half a day of your time. 1300 222 774. Billy in Flowerdale. Hi, Billy. What's going on?
Hello, Billy.
Hello. My niece wants to buy half of my property. I've got a property with a few acres, and I got the house, and I was going to put a cabin in the other paddock and live in that. And I thought if I could sell the house, could I half the house to her? Could I say, well, you get that half, and I'll get this half?
Oh, it sounds horrible, Billy. You're trying to subdivide, are you?
Well, not subdivide, but I want to downsize but stay here. I love it here. It's a nice place, even though it did get a bit flooded, down the bottom.
Billy, too, there's a couple of things. The selling a half interest to your niece sounds fine to me. You just need to remember that if she wants out at any point, she can force the sale of the whole property. So that might be unacceptable to you. You could protect yourself by taking a lease at the same time. What I'd be doing, though, is, were you Murrindindi?
Yes.
I'd be looking at the planning scheme about whether it's possible to build a second residence on your property.
Yes, so I think as a transportable building.
I would. That to me is the most important thing from your perspective, is because there's no point selling her a half interest in the property if you haven't got anywhere to live.
Can you make it that she can only sell her half share rather than the whole property?
There's a provision. No, she's able to force a sale, because why would I want to come along and buy from your niece a half interest in the property where you're there? I would be coming along and saying, well, I'll buy it from your niece at a discount and sell it at a profit, Billy. That's the way it works. So I would be suggesting...
you might... One building on a half acre and another building on another half acre.
Then, look, depending on where you are, if you're in... it might be possible to subdivide.
Yeah, I don't think so, no.
Well, I'd be looking at it from a planning and building point of view first, because that's where you really want to start.
And if there was a subdivision, is that going to be very expensive for Billy to do?
Well, depends upon... from what Billy's telling me, he's only got an acre. Now, if you subdivide that in 2 half-acre blocks, there'll be issues in relation to sewerage and septic and supply of services.
Yep.
So your first question is, depending on the zoning of the property, if he's in the Flowerdale township, it should be doable. He then ends up... So you would put your daughter on your niece on the title, and then you would do a subdivision. But but simply because you'd pay less stamp duty.
Is that the wiser, the safer way to do it?
Your starting point is, can I build a second residence? Because Billy doesn't get anything that he wants unless he can get a second residence.
Right. You better check that out first, Billy.
Okay. Thanks very much.
Thanks so much. Nice to hear from you. Thanks for calling in. Ramu in Keysborough, what's going on?
Hi, thank you for taking my call. Yes, I have a neighbor has got a tree which is 8 to 10 meters tall. It sits right next to the fence, and its leaves are really tiny, and it falls and it creates like nuisance and debris on my property. Just wondering what are my options.
Your options are what do you want? Do you want the trees to go, or you just want the leaves cleaned up?
To start, my first option would be to tree to go. I've spoken to the tenant next door. I asked him, requested him to communicate that to landlord, but I haven't heard anything.
Well, it's the owner's problem, not the tenant's problem. And you have an action against your neighbour to restrain a continuing nuisance, which could be by either cutting the trees or coming in and cleaning them, or paying you to get rid of the leaves. That's where I'd start the discussion. Ask you can do a title search for the property next door, and you can find out who the owner is.
Okay, and I can approach them, is it correct?
Yeah, you would approach the owner and say, I have these problems with your trees. I've got an ongoing problem. They continually drop leaves. The leaves are an irritation. I need it fixed.
Oh, okay. Sounds good. Okay. Thank you. Thank you very much.
Thank you.
Do you think he'll get a positive response from the owner of the property?
No.
Right.
No, you've got...
What does Ramu do next then?
Well, he could go to the... Well, it's not a VCAT matter. It's a matter that goes to the Magistrates Court. And years ago I was involved in one in Camberwell where they were old pine trees and they dropped branches. But they also dropped lots of pine needles. So who cleans up?
The owner of the tree does?
Yes.
Yes. But getting them to do it is the thing.
A different question, yeah.
My heart always sinks whenever you talk about going to the Magistrates Court. Do I have a misapprehension about how challenging, time-absorbing, difficult and expensive that is? Is it actually easier to achieve and get something heard at the Magistrates Court than I realise?
No.
Right.
No, it's COVID slowed it all down.
Yep.
Backlogs at the Magistrates Court was horrendous. I mean, I've been involved in a fencing dispute in the Magistrates Court that cost $58,000.
And do you need to brief counsel? Do you need to hire
as a general
lawyer?
proposition? The VCAT's a jurisdiction where the normal rules of evidence don't apply. In the Magistrate, County and Supreme, they do. So the way you prove things is far more formal. The structure is far more formal, and yes, I like VCAT because you don't make an appointment. Magistrates Court, you join the queue.
That's right. 1300 222 774. Alan in Geelong, go ahead.
Hello. Look, I'm calling about the rules that apply to the use of power of attorney.
Mm-hmm.
If I'm asked to have a power of attorney for an older person who is probably going to be beyond the ability to manage her own affairs within a short time, what should I do? Should I insist upon a payment for that?
Okay, the standard form standard form power of attorney is prepared on the assumption that you are doing this on an unpaid basis. If you are going to be paid for taking on the job, then I would be suggesting that the power of attorney should include the basis of payment.
Yep.
Can I also say that if this person loses capacity, it's no longer discretionary for you, Alan. You are now obliged to step up. So
in what way?
Well, you're required to act as the attorney. If you come along and say, I don't want to do this, you go off to VCAT and say, I don't want to act for this little old lady anymore. I please go find someone else.
Yep.
So...
I was told about a case where the person with the power of attorney was frequently given generous offers which were refused. And in the end, when that elder person was incapacitated, an amount was taken, which was later disputed because...
yes, so I'm saying that's why...
There's no evidence.
The assumption in the Powers of Attorney Act is that if you've got a power of attorney, you are unpaid.
Yeah.
Yep.
You can overcome that assumption by including it in the document.
But if you don't do that and take payment for yourself...
Then the answer was you've got to give it back. Now, reimbursement for expenses is not the same as payment.
Right.
So you'd be prepared to do this, Alan, if you were paid, is what you're saying?
I think it just seems like it'd be a more business-like sort of setup.
Right.
But I was wondering, if you take a payment without something on paper, is it actually illegal or is it just regarded as improper?
A and B. It's both illegal and it's improper. The assumption,
stealing.
Alan, is that you have this discussion with the person who gives you the power and they agree to pay you before you start working.
If they agree to it.
Yes.
So there's a discussion to be had there. Good luck with that. Let's stay with power of attorney. Norma in Ringwood, what's your power of attorney question?
Hi, David and Virginia. Thank you. I've got a friend of mine whose mother is in aged care. Her brother has taken most of the responsibility for looking after the situation with contacting the aged care, and she's had a falling out now with said brother and wants to know how she finds out or how she gets a copy of the power of attorney, because she believed that many years ago they both signed it.
Ask the aged care facility. People
They're
who
saying
enter...
that they...
Beg your pardon?
Sorry. Aged care saying they can only deal with one relative.
That's a different question. You're not asking them to deal with you. You're asking, do they have a power of attorney for the resident? And if so, are you named on the power of attorney?
Okay, that's simple, which is great.
Well, I understand the desire to only deal with one person, but you're only asking for a copy of a document with your name on it. And if they won't give it to you, can they tell you who the witnesses were and who prepared it?
They will have a copy of it, David?
But when you move into aged care, the aged care provider really wants to know whether you've got a power of attorney and can I have a copy, the appointment of a medical treatment decision maker or a medical treatment power of attorney.
Or an
and can I
advanced
have a
care
copy?
directive, yes.
Advanced care directive, ideally, and also who's got your will? Sorry, who's the executor under your will?
Yep. So that should all be there. Norma, good luck.
That sounds great. Thank you very much for your help.
Thank you. Nice to hear from you. Catherine in Fitzroy. Catherine, hi. What's your question for David?
Oh, hello, David. This is a will question. My mother died recently and her property is to be sold and divided equally amongst my siblings and I, so there's no issues with any of that. One of my sisters has been appointed as executor, and she has, I've come to. I'm just wondering what transparency looks like with regards to things like appointing a real estate agent. She's currently there's not a lot of communication.
Oh, well, she's not obliged to tell you a great deal. I take it you've got an equal share of the estate, Catherine?
Yes, I just want to add one more point. She's in the process, we've become aware that she's in the process of appointing the real estate agent, but her son, who is also a beneficiary of the will, works for this agent. And we don't believe this agent is qualified, is appropriate to sell this property.
Is that because of the value of the property or the address of the estate agent?
Well, it's a number of factors. They're not in the area. They don't have a background in this type of property. All those sorts of things that you normally consider when you
Catherine,
sell a property.
I would be at a different point. I'd be saying, I'd be going off and getting some appraisal as to the value of the property.
Yeah.
And my view would be I don't care who she appoints, I just want to make sure she gets fair value for the property.
Right. So you don't think that it's acceptable to use an agent where another beneficiary of the will is working?
It's a bit convoluted, Catherine, because your sister is presumably also a beneficiary.
Yes, she is.
And there you get to that interesting question, is there always self-interest if a beneficiary is also the executor? But in 99% of wills, the executor is a beneficiary.
Yeah.
Catherine, it's really it's not something I would want to go to court over. My concerns would be whether or not you're paying the agent the right rate of commission, and whether you're overpaying or underpaying, but there'll be a market rate for what commission is in the area.
Yeah.
They would be my issues rather than the appointment for the agent. And you might ask your sister whether or not she sought quotes from other agents. But I wouldn't be going to the Supreme Court over whether or not it's appropriate to appoint X as an agent.
And fundamentally, it'll be the right of the executor to
choose.
To
yes.
choose.
Yep.
And no correspondence has to be entered into about that.
No. It might be, if the property was sold for $300,000 under value, then we'll have an argument about whether she behaved appropriately.
Okay. I hope that's helpful, Catherine. Anne in Echuca, which is in the news this morning. Anne, how are you going? Good morning. You under flood threat there?
Good morning. Good morning, Virginia and David. Thanks for taking my call.
That's all right.
My question is around capital gains tax on a property that was purchased in 1981 but held in trust for me. The transfer to my name was after capital gains tax came in. So I'm wondering what your thoughts are on that.
Well, then from a capital gains perspective, there's not been an acquisition. So it should still be a pre-CGT asset because there's no change in beneficial ownership. Your difficulty, Anna, will be in proving it. So I would be looking at the transfer that was signed to put the property in your name, and if it said entitled in equity, then that would say there's no beneficial ownership change, but if it has a consideration, a money amount, then you've got more difficulty.
I think it says something like that. There doesn't seem to be any capital gains tax involved when it was transferred to my name.
No, there wouldn't have been at that point because, let's assume you got it, let's assume it was bought in 1981, it went into your name in 1990. Yeah. That if it was, let's say I bought it in 1990, it would have been treated by the people who bought it in 1981 as a pre-CGT asset, no capital gains tax payable. I would acquire the property at market value in 1990. In your case, if you're able to establish, and you may well get asked, how do we know that the property was always yours beneficially and promised to you is not the same as yours beneficially, then there is no capital gains tax disposal until such time as you dispose of it.
Okay.
Does that help?
What makes it classed as mine beneficially?
Well, where's the evidence that it was always yours?
There are various documents.
Well, then it would require an analysis of those documents to satisfy the Australian Taxation Office that it's always been yours and was yours in 1981, even though it was held in someone else's name for a period of time.
We'll have to leave it there. I hope that's some beginning guidance, Anne, and good luck with the situation in Echuca. David, always good to see you. Thank you. David Whiting there, who's back with you next Tuesday.